Hello, good morning, and welcome back to the Legal Giant Show. I'm your host, Nicholas Newsum, and we'll be talking about a few things here. But first, happy Independence Day belated, and happy belated 4th of July to all of you who are finally tuning in here. It'll come in sometime around the following morning if you're tuning in on first release date. It's been some time since we last spoke, but I want to wish everybody and hope everybody had excellent and safe, healthy Independence Day over the weekend. Now, the Independence holiday has always held with it kind of a dichotomy, and I always feel a little torn, especially in my last few years as an adult, as things have kind of changed here a little bit in America, and between two worlds. And we'll kind of talk about that here a little bit more today. But I just hope everybody had a safe and healthy weekend. But it is something to think about. What is Independence Day? What are we celebrating independence from? If we stick to the strict historical meaning, it's a celebration of freedom from independence of Britain. And yes, to that extent, I haven't been oppressed by a British citizen in recent recollect or memory for as far as I can recall. But if what we're really celebrating is independence from oppression, it should be celebration of freedom of independence of oppression from both within and without. And I think that still rings historically true because there was a number of British citizens who were also on American soil at the time who remained British loyalists. And so as we have this time to think about what is Independence Day all about, it's something I want to bring up and have people think about this conflict. And we'll demonstrate here. Of course, we always talk about the great giant legal issues of our time, and that's what the Legal Giant Show is about. And of course, because both myself and the number of my guests are practice labor law or workers' compensation, we always try to cover some workers' compensation or labor law subjects as well in each show. And I definitely picked out a couple of cases that, though they seem to be in line with the direct meaning, there's definitely an undercurrent, and then there's also a disconnect there. And I'm going to bring that to the fore and show what it does to someone when there is a disconnect, and then we'll try to tie that into the greater meaning. But if you tuned into our first show, though, I'm extremely proud to point out that in the first Legal Giant Show, I personally broke what was international news that would be divulged and discovered, I think, about 45 days later, and the entire mass media would come out and point out that the Wuhan virus was actually originated or best believed to be related in that Wuhan lab, and that there may have been some World Health Organization funding. And I know I watched Dr. Fauci deny any knowledge of the World Health Organization personally funding gain-of-function research. And I also want to point out that Joe Rogan, about 30 days to 60 days later after all this became large international news, pointed out as well that this gain-of-function research might just be inherently dangerous. And I think that was an idea that I was trying to propone before, that if we have the leader and foremost authority on gain-of-function research is the same individual that's going to contain the gain-of-function research, there is a bit of a disconnect in regards to the ethics of it all. It's the same person who's in charge of making sure it survives. So it almost negates there ever being an option to potentially turn off that gain-of-function research. But most importantly, not to rehash old subjects, if you tuned in, you would have saw really good coverage of the vaccine. But it's important to point out that our show, I believe, is one of the first ones, the Legal Giant Show, is one of the first ones to ever break the news about the true location of the Wuhan lab, at least the revival of the disclosure of that location. And then there's also another one. Andrew Sexton, who was on this show last time, pointed out clearly that there's likely going to be some backlash to these vaccines, some negative aspects and side effects. And now we've seen a couple it was just revealed in Australia that the AstraZeneca vaccine used a spike protein in the vaccine there, and the spike protein was from the HIV virus. It's a clamp spike protein that helps choke off transmission. However, they were having massive problems with giving positive HIV tests to individuals who had otherwise not deemed positive HIV and had only had a vaccine, the AstraZeneca vaccine. And so that's been discontinued. More importantly for us here in the United States, the FDA released a update on the vaccine, placing a warning for Moderna, Pfizer, and one other vaccine that's commonly used here, and they all were provided a warning for some type of vascular concern following the virus. And so that's another huge bit of information that was first broke or revived here on the Legal Giant Show. And this isn't a brag hour, but it's to point out that there was important topics covered on this show, and that we do stand behind the information that we divulge here. Now, of course, this is not legal advice, and if you would like legal advice, you need to get in touch with an attorney. I am an attorney here in the San Diego area, and I practice a number of areas of law. One of my most passionate area of law that I practice is anti-discrimination. And when I say anti-discrimination, I mean it in all aspects. It most commonly comes into my office through either a claim of employment discrimination, passover for supervisory position. I've also experienced a number of times where an individual has been treated completely differently from everyone else. And as a result, they aren't able to understand why, if they're showing up and doing everything the same as everyone else, they're lifting the same load, they're punching the same clock. Oftentimes, these individuals take it upon themselves to work even harder than their counterparts, not because they're a better individual, but because they want to set themselves apart and make sure that they're doing their part, and in fact, ensure the best quality work possible to ensure that managerial position, and yet repeatedly get passed over. And in those instances where there's been specific comments about someone's national origin or ethnicity or religious background, or gender identity or sexual orientation in the state of California, especially in relation to employment or to certain contractual governmental rights, those actions are completely illegal. They're not just wrong and morally wrong, they're completely illegal. And I personally, being an individual of multiple mixed race background and having my own experience in life with it, feel deeply and passionately about these cases, and I'm very pleased to be able to provide this service to the San Diego community and make sure that we have a better and more robust, more diverse economy based upon true merit and nothing else. In fact, I've never told this to anyone before, but I have a very personal close story with it myself in my family history. My mother's grandfather, Granville Dean Villa, may he rest in peace, no longer with us, was not only a decorated war hero, and in times of war he actually received the medal just underneath the Medal of Honor, is my understanding. Something he didn't readily talk about much. But more important to me is that after my grandfather had came back from the war, and he married my grandmother, Frances Villa, who wanted to be an educator at the time in the Midwest, and I want to say it was Nebraska. I could be wrong. It might have been somewhere else around there, maybe a little bit further south, or can't quite recall the name of the state, but I do remember the gist of the story, and it was something as to the effect of my grandmother applied to be just a secretary in a district office at the time, with the chance of course, moving up. But instead of just giving my grandmother the job, when she found out that her last name was Villa and that my grandfather was of mixed and Spanish descent, they were unable to give her the job right away. In fact, my grandmother, who happens to be the darker of the two, who's got the curly hair and the brown eyes and the at least somewhat more olive skin, which I've inherited, was not the one being the subject. No, rather, my grandfather, who had obviously... Sorry, it's tough for me to get this out as I think about it. It's very frustrating for me. But obviously ethnic name, he was forced to be a passenger in this car so he could be driven around to each of the other superintendents' houses in this state in the Midwest. Also, they can get a look at my grandfather to see if he was too ethnic looking. And the implication was that if he was too ethnic looking, he wouldn't get the job. I guess I should be grateful for them historically that they were able to get the job, because actually my grandfather happens to be fairly light complected and in somewhat contrast to my grandmother. And I can't help but feel it wasn't just my grandfather that they were checking out, because they simultaneously were triggered, most likely from my grandmother's appearance. And so that's a story that for these two individuals, they go on to give you some background. My grandfather ends up being the principal of a little school called Stratford. It's a predominantly 99.9% Mexican and Latin descent school right outside of Lemoore, California. And he is affectionately dubbed Big Daddy Cougar. And I can only tell you how many times when going to high school, even though I never went to Stratford, all of those kids knew and adored my grandfather, because he continued to give back to his community just simply because. Right, and even more so because he knew the struggles of being a minority in this country, even though he was a decorated war hero. In fact, well after his retirement, he would give a number of years into coaching track and other things to continue to give back to the Stratford School. And eternally grateful to have him as a grandfather. And of course, my grandmother ends up being a major superintendent in the Kings County area, and essentially oversees and helps teach the next batch of teachers. And I mean, when I say the next batch of teachers, I mean for almost the entire county. I don't want to overstate it. I'm sure it wasn't every single teacher, but at least it was portrayed to me that way. And I do recall that when my grandmother passed, the entire small town of Lemoore closed down. And the only reason I bring that up isn't to brag, although I'm very, very proud of my family heritage, and especially my mother's background. I think the most important part is that while we sit here and we think about these things, these sweet individuals who were in fact subjected to racism. I mean, it doesn't get much more racist than that. You qualify for the job, but because your husband has a Spanish last name and because you look so dark complected, I need you to drive your husband around to all these superintendent houses to get cleared, right? I mean, anyways. Think about what you're doing. I mean, you're discriminating and almost preventing the entry of these two wonderful individuals into the education community of Lemoore that essentially helped educate the entire next future generation. I know a number of people who've gone on to be lawyers and doctors and members of the community, or to give back to the community, not the least of which are some of her own grandchildren or any of these other children that grew up in this economically inundated area. So yeah, let's talk about that dichotomy now in Independence Day. I grew up in a military town, Lemoore, California, and I respect and revere all of our service members and really appreciate the sacrifices of the few so the many of us can experience freedom. But if it's freedom from oppression, both without and within, we have to address the dichotomy of the pain that must reside inside of our fellow Americans that don't feel that they can celebrate the United States of America flag or the Pledge of Allegiance. And I'm not saying that in a way that I'm not finger pointing. I want you to think about that. You're somebody who gets to represent the United States of America. There was even that Olympic athlete, and they felt compelled to turn away. I'm unable to reconcile the two. I've heard other members of our armed services express their own dismay with the fact that although they were told that they're all green or they're all blue now, that it wasn't so much so. If Independence Day is about oppression from both without and within, then I think there is both something to stand for the flag and to appreciate that we've got this far, but there's also likely something to, at the very least, reflect upon, if not kneel about. The oppression's real. It's still going on. I myself have had my own experiences in life, and in fact, you may or may not believe it, but I had my own experience this year with racism. Now, I've forgiven those involved, and if they're watching, you're forgiven. I hold no ill will for you. But that doesn't change the fact that there is a dichotomy in our society, and things aren't always equal when they should be. And so, right before our next break, I want you to think about that, not from your political standpoint or what's right or what's wrong, but just think about independence and what that means. Oppression from what? And whether or not we have some more cleaning to do in our backyard. When we get back, we'll talk to you a little bit more about the Independence Day portion of it and what discrimination looks like in our society, and then we'll segue into some legal analysis from the Workers' Compensation Board and some of the dichotomies there, right after this break. Hello, my name is Nicholas Newsum. I am the founding member and managing attorney of NHN Law Offices, a trial consulting and representative firm in the San Diego, California area. When I got first started in the legal field, I understood early on that relationships and connections were as important, if not more important, than understanding the law. I immediately began to amass myself a network of connections of individuals that I thought were not only high quality and worthy individuals, but people who were trustworthy and would get the job done when needed. I have amassed a large network of fellow attorneys, doctors, investigators, and even some fellow judges who I've consulted at times to be able to propone the best arguments for my clients to provide maximum success ratios, even when taking cases to trial. As a result, if you or a loved one is in need of any legal assistance, please reach out to us at NHN Law Offices. We're here to help.
Have you been hurt at work? Struggling with a workers' compensation claim? Dealing with a heartless insurance company? If you're not receiving disability payments or satisfactory medical treatment, or you're unhappy with your attorney, you're not alone. Unfortunately, many injured employees face issues with their workers' compensation case. Don't be overwhelmed. You have rights. The Sexton Law Firm helps injured workers navigate through the workers' compensation maze to maximize their monetary recovery and prevent them from being taken advantage of by insurance companies. James F. Sexton is a former lead attorney for an insurance company. He knows how the other side thinks and the hidden inside secrets insurance companies don't want you to know. The Sexton Law Firm has a no-win, no-fee guarantee. This means that if we don't win your case, you don't pay at all. Call today. Let the Sexton Law Firm get you the benefits you deserve. 619-870-1688.
All right, and we're back. Thank you for sticking with us after that commercial break. I'm your host, Nicholas Newsum, and this is the Legal Giant Show. Just before break, we were speaking about, almost in a somber tone, the dichotomy in the Independence Day and what it means for all Americans. And I want to touch on another issue before we segue into some other stuff. Recently here, which struck national news, was the Coronado basketball tournament. And mind you, this is a high school basketball team in Coronado that claims the reason they threw tortillas at their predominantly Hispanic opponent basketball team was a celebration tradition out of Santa Barbara College, proponed by this individual who's apparently a booster of the Coronado basketball team. Now, I can't tell you whether or not the intent of these individuals was to intentionally act in a racist manner towards the opposing team. But what I can say is that in 2021, if you can't understand the alternative interpretation when one throws a tortilla, which is a food item mostly associated with a specific ethnic food group, i.e. Mexican food, and then you, a predominantly white, if not all white basketball team, then choose to throw those tortillas either in the air, or some people even throw them at or in the direction of the opposing team, how that might be considered racist, then you might need to have one of those racial sensitivity trainings that we all love to participate in our corporate jobs. Because it would seem to me that the tinge of racism is at least readily apparent there. And if you can't root that out, I think you probably need to go back and get a little education study into what's been going on here in the last 10 or 20 years in the history of the nation. I think I would also point out that this hasn't been a Coronado basketball tradition. There was no prior disclosure or approval from the Scholastic Federation to say you can throw these tortillas in celebration. And so I think they're well within their rights to remove it, because it's not just about being best in basketball. It's what it means to be a champion in general, and to what that means to be a representative of a championship team. And that kind of conduct is the kind of conduct which is subject to dual interpretations. And if the Scholastic Federation felt it need to take action, then by all means, I'm going to leave it within the general jurisdiction of the authorities. And if nothing else, this should be a great lesson learned for everybody involved, no matter what the outcome is. So, yeah, about the dichotomy. All I can say about that is I readily put my money where my mouth is, and I try to assist those who have been subjected to discrimination here in the San Diego area and give them positive advisements on how to better protect their rights and protect themselves. And I also, of course, try to give solid guidance towards perseverance over these oppressions, whether or not it's through legal means or other. Now, one of the things that really creates this conflict, I guess, on Independence Day is that on one hand, I want to be so grateful towards all of the service members in my upbringing and education. Being entirely born on the Naval Air Station in Lemoore, I was all the way from first grade all the way through eighth grade, educated on military base, and all the glory that comes with. That being said, I also can't ignore the fact that I've seen our male and female service members express to me very much so some concerns, or that individuals of certain ethnic minorities here in the United States don't feel that they can readily participate in certain patriotic activities. And I can't help but feel like maybe this day is lessened for them a little bit until we all acknowledge and figure out how to be better ourselves. Now, with that is essentially just it's a conflict, and we all are going to have to address it so we can make it less conflicting, right? And speaking of conflict in just society, but also in law, we have this 2020 case, Loring Williams versus Chino Valley Independent Fire District, and this is a September 2020 case, so this is late last year. We're not even talking 8 or 9 months removed now, and this was by Deputy Commissioner Schmitz, Chair Zalewski, and Commissioner Razzo. And there's two great gists of this. I mean, if you don't know already, and you're an applicant attorney in the area, there's been multiple cases now, and it essentially says that if defendants issue a utilization review certifying or authorizing the treatment, irrespective of whether or not the courts believe that it was properly asserted or was previously a body part involved in the claim, that if you don't act and purposely avail yourself to the panel QME process under 4062, you're going to swallow the pill whether you like it or not. And further, if a UR certification issues, you actually no longer have any right to dispute that treatment. And the case we're going to follow up afterwards which was written by Clint Feddersen and actually by the same panel of WCAB commissioners, comes to the same conclusion about UR. However, a completely different conclusion on the tangential issue, which is still very important to any practicing defense attorneys. Since I do practice as a defense attorney in the area for certain particular clients and started out my career wholly 100% as a defense attorney, I can tell you from experience that these cases, when they come out, defense attorneys, especially the sharp ones that are out at the precipice in the forefront of expanding the defense law, they look for these things. And in the Loring-Williams case, subnote 5, it goes over the Sandhagen acknowledgement about approving treatment requests under UR and analyzing 4610. But I'll just read it here in its plain language for you so the attorneys in the group can make their own analysis. But it says simply, the Supreme Court in Sandhagen found that the employer may not challenge a physician's treatment request through the medical legal process in section 4062. Supra Sandhagen 44 Cal 4th at PP 236-237. Now, we all know that to be the rule, right? But I always never liked that rule because it barred the idea of getting another physician's opinion, and they're just that. Until a legal theory becomes a legal rule, it's just that, a theory or a philosophy, and then certain ones propone one way and certain ones propone the other way. And the medical field is even more so that way. And until it's definitively black or white, I thought more physician opinions would be better than one. Now, if you continue to read this footnote, it continues and says, however, in section 4610, subdivisions L and M were not in 4610 at the time Sandhagen was decided, and because they were subsequently added to the statute, it leads defendants the ability to challenge medical treatment recommendations through the 4062 process. And I thought, brilliant. What a great place to hide it so somebody can utilize it at the right factual point in a case and create better law. Unfortunately, not but 7 months later, on April 2021, the WCAB, through Clint Feddersen, and again with the WCAP panel, but this time I think this one's written by Razzo, but it sits Razzo, Schmitz again, and Zalewski. And this also determines that an applicant would be entitled to the treatment based upon a UR issue, but more importantly, added that age-old language that was previously challenged under the Loring-Williams case, and specifically says in plain black and white English, it's improper to challenge the treating physician's opinion by going to the 4062 process. And the reason I thought that was conflicting is because they just issued a case with a footnote that logically tracked, which had 4610 L and M, which inferred that the med legal process should somewhat be involved in making these determinations of what is proper treatment parameters. And I think it also tracks more logically because if I'm a medical treatment physician and I'm recommending all this treatment to an individual, of course I believe it's necessary and reasonable. And if that's the only opinion that ever gets to go to the UR to determine whether or not that treatment needs to go forward, then it seems to be the fox guarding the hen house, as it were. But the QMEs are certified state physicians that are even licensed at a higher grade, arguably, than a regular treatment physician to not only understand the medical side of treating these injuries, but also the legal side of workers' compensation so they can properly report and participate within the system so lawyers can do a better job at what they need to do. And yet, we're saying that we can't use them to rebut treatment opinions when their opinion is most likely to be unbiased, right? Because they're not having to provide the treatment on a regular basis. And in fact, in the 2021 case written by Clint Feddersen, I'm certain the defendants would wholeheartedly agree with me because what they were fighting over was home health care. And man, the lifetime span costs of home health care could exceed over $1 million easily, depending on life expectancy and the level of treatment and care that's needed in the home. Skilled nursing facility is likely a secondary step in that, and that is certain to cost you, if you have substantial life left, is certain to cost over $1 million as well. So I'll leave it to you, viewers. What do you think? Do you think that you should be able to ask a QME about treatment recommendations and whether or not those treatment recommendations should hold some weight with regards to reasonable necessity of treatment, or should it just be the treatment and the UR opinion, the treating physician, the UR opinion? I don't know, but I do know that when there's dichotomies like this, when a defense attorney reads a 2020 Loring Williams case, and given the delay in trial timeframes, by the time the issue comes up for dispute in December or January, where they found a case that has a legitimate enough treatment, say home health care, like in the Clint veteran 2021 case, specifically the name of the case, let me get that for you real quick. 2021 case of Daniel Casarati versus Cisco's Mexican Restaurant and Star Insurance Company. That's 2021 Calware Comp PD Lexus 125. Original opinion written by the WCJ out of Van Nuys, Clint Feddersen. And when you see these two cases, and by the time you're able to get that dispute in December, and you get a conference date in February or March, and you're able to set it out for trial in June on the specific issue that you have, and then the courts issue new guidance in the Casarati case and say, no, actually, we take that back. You can't challenge any treatment recommendations through the 4062. It just seems to me that that's going to create some conflict and some tension there, and it's going to create some misunderstanding. The defense attorney is going to then have to go tell his client, remember I told you we had some really creative reading on this footnote, and looks like there's some unique case law here just sitting, and it's a little more than dicta because it was used to analyze the outcome in this case. It just seems to be valid, and now they clear guidance in the opposite direction. It's even the same 3-panel WCAB commissioners, and it goes the other way. And now this defense attorney, whoever said it, if this happened, is going to have to converse with their client, explain to them why this now moot issue and was previously somewhat considered well groveled law was rehearsed. And I could simply say, good for you. You're being creative. You're being aggressive. You're within the bounds of the law. I personally agreed with that reading as well. And I think you're fighting the good fight. And if any client is giving you too much trouble, I say just breathe. Understand that every client's different, because I know other ones out there that would probably still want you to press it all the way through even after giving the new initial guidance. So awesome. Well, it looks like we're getting pushed for another commercial break here. And after this break, I'm going to give you a few more tips and then we'll sign off.
Trusts aren't just for the super rich. It can take a year to probate a modest homeowner's estate, eating 6 to 8% of the estate's value. A trust can speed things up and preserve assets. The Sexton Law Firm.
Outside of making the choice that you want more out of life, nothing's more important than education. The vast majority of what we provide here at Alpha Research is education, and it's my personal belief that education will take you from where you are to where you want to be. I can take this proven program of success and apply it to your situation and help you achieve the same results. But don't take it from me. Take it from our most recent Alpha Research success story.
Nick has helped me a lot with the way that I see myself and the way that my confidence comes true, and motivating me to keep trying to succeed, even though a lot of the time, law school can be very hard on you. But he's there. He's always there to encourage me and motivate me and help me out whenever I'm feeling a little bit defeated. I would recommend his program to anyone. I think that Alpha Research is an incredible product, an incredible company. If you're ready to take the next step and become a better version of yourself, Nick is here for you, and he's willing to help you show your true potential to the world.
What you just saw isn't one individual success story after taking our educational success ladder program. The same could happen for you, and all you have to do is take the steps necessary and click the link below. And we're back. Welcome back to the Legal Giant Show. I'm your host, Nicholas Newsum. Just finishing up here. During the break, I had some colleagues speak to me, and they wanted to talk about the compelled speech portion. Really distasteful, in my humble opinion. I've never been a big fan of any type of speech regulations one way or the other. And compelled speech, telling me what to say, is got to be one of my least favorite of any of the activities that one could propone forward from a legal standpoint. And so to the extent that anything that I said earlier about kneeling or trying to understand another side's point of view, I want to go on the record and say that if you are compelling people to say what you want them to say, or to kneel on your behalf, if that's a mandatory activity for you to coincide with them, then you and I don't align. And I don't mean that in a negative way, like, oh, I dislike you, but I mean that in the sense that I'm about what is true personal freedoms, right? And the reason I find racism so abhorrent is it's blocking you from that inalienable right of the pursuit of happiness, of your true personal freedom, of to be free from subjects of racism, okay? To be free from someone calling you any racial epitaphs in your workplace or in a governmental setting or anywhere where you're forced or compelled to be, or on an airplane where someone might mutter to you that you have mongoloid blood or something as to that effect. Then yes, that's wrong. And if you've been so afflicted, I want you to feel free to give me a call. We give out free consultations all day, and I will give them out all day and twice on Sunday if you've been the victim of any type of abhorrent racism. That being said, I just don't agree with compelling speech or forcing somebody to kneel if they don't agree to kneel. And that goes for forcing someone to stand for the flag or national anthem if they don't feel compelled or if they don't feel like they can fruitfully participate. And I'll even take it a step further. If you knew that you were causing this individual emotional and social harm because it failed to acknowledge their trials and tribulations and struggles in life, then shame on you too. Okay? And that goes for anybody who wants to defend other tangible racist activities that we may have discussed here in this podcast, that whether or not the intent was to be racist, if it was interpreted that way and it wasn't immediately adhered to and acknowledged, and rather it sounds like both sides became rather adamant and aggressive with one another, then it just seems to be the exact type of thing that doesn't propone championship behavior and doesn't behoove the United States of America and doesn't speak to the America that I was raised to live in, because my grandfather never held a chip on his shoulder. My grandmother never held a chip on their shoulder, and they gave back every day until they passed. And I intend to do the same thing. Okay? So until things are a little bit more clear and we get better guidance from the WCAB and we understand whether or not we can challenge these treatment issues, and until more people can understand the plight of both sides, right, of both the service members and those that have sacrificed already for freedoms, and find the importance in standing and being patriotic, and those that have been oppressed and that are continually oppressed till this day, and until we understand both these sides. I'm Nicholas Newsum, and I just want to say this is the Lingo Giant Show. Thank you for tuning in.
Undercover lovers infecting the industry, and even undercover others that give you the ministry. I know that I ain't perfect, I know I'm a sinner, G, but I'm hoping if you listening, you feeling my synergy. Amen. Man, so many. Wish the worst on me. Wish the worst on me. Till I bring that May.